Madan sir, I'll just tell you, I have told two things. Either trading should stop. Second point I have told that if trading you are not stopping, then what you have to do, you have to write clearly that this company is in shares. This is point. Second is you and me who are those who can do research. They are
your voice is cracking.
I can number.
We can't hear you, sir.
Is it okay now?
Yeah, it's fine now.
Yeah.
I can give you the number that a company has a X number of shareholder, and after this happened, that it had gone to CIRC, there's the insolvency process, then number of shareholders has increased. It means, and who has increased? The small shareholders. So it means there is something wrong happening, that these poor investors, they see the share Unitech, which was 300, 400 rupees and available at 1 rupee. So they tend to buy shares. So number increasing is an indication that a small shareholder is always come into trap. And these are the new shareholder, not the existing shareholder. This is Pradan. Rest of the thing you have agreed.
Agreed.
Mr. Madan, in addition to what Pawan sir said, I think if Anjali gets an exit, maybe Mr. Madan will be the next person who will be stuck in the list of the shareholders. So getting suspended, at least we are putting a break on the trading that is happening on a daily basis. And whosoever was the shareholder on a particular date will continue to remain the shareholder. No new people will be able to join in.
But there's a risk. That's what I'm saying, Anjali. There's a risk. And from the day one, the way the companies get into CIRP, from that day till the resolution plan is approved and company gets delisted, he's not having any exit route at also. If in the meantime,
that is the
if in the meantime, if there are certain risk takers, if you have a separate segment for these companies, trading for these companies, and buyer knows it very well that he's buying the shares of a company under CIRP, if he's ready to buy it, let him buy it, and let there be an exit opportunity for the existing shareholders.
Madan, then they have to make a separate segment, that is T2T
That's what
segment,
I'm saying. Yes.
Where people are aware that this is the company which is risky, and then window is open, then you are taking risk, and they should mention all the risk. That's why I'm saying.
True. I agree.
Yeah.
Currently, you want to say something on this?
Yes, so I agree and disagree on a lot of issues, but predominantly what I agree on this is that there should be a full disclosure about the initiation of CRP process in public at large through stock exchange. This I definitely agree that public stakeholders, shareholders, public shareholders should have and are entitled to have full knowledge about the CRP process being initiated. So this one thing I completely agree with, and I think that there should be somehow a bridge or a link between NCLT or the IRP and the stock exchanges, so that the information is on the public platform at the at the present as soon as possible, and the stakeholders can then take a decision whether they want to continue to hold shareholding or they want to exit. Having said that, I also agree. I somehow agree with Madan Sahab that the trading should not completely block immediately on day one of admission, because shareholders may want to continue and they may want to see how things are evolving and how things are moving, and then they may decide to move out of or they can exit. So this is my point of view, and I would request Abhishek, now he's here, I can see him, if he could also share something, and then we can go ahead.
Before Abhishek says, the LODR has already been amended to this respect. The IRPs and RPs are mandated to give this intimation to stock exchange on a routine basis. But my viewpoint is, the moment a company, the admission order is passed, I think copy of the order should be sent to SEBI and the stock exchanges also immediately by NCLT itself. We should give that suggestion also. A copy of this should be, the moment is in the order shall be sent to ROC and blah, blah. Along with the ROC, it should be sent to SEBI and stock exchanges also, because in the application it is very clearly mentioned that where the shares of the companies are listed. that intimation must go immediately and stock exchange must act on that intimation immediately. Yes, Abhishek ji.
I completely agree.
The first apologies to join late. Good evening to everyone. In fact, sir, I agree to what you just said, that the copy of NCLT order should in fact be sent first to SEBI, so that it is not only shareholders, I would say, in fact, even creditors who are looking at a SEBI website may come to know which knowledge may not be there by any other communication or any other means. And I also agree to Karan's suggestion as well with respect to the trading during the moratorium period should be continued. Now, I agree to a certain extent, but there may be certain issues arising out of the trading, which may not fall within the purview of moratorium. Whether that transfer, because ultimately shareholding can be treated to be an asset. Now, the moment moratorium is applicable, whether that shareholding can be transferred to someone during the moratorium period will be a question which ultimately may be evolved during the period of time. But today, I would say that if that trading continues and a shareholder is given an opportunity to then transfer his shareholding, would that fall within the definition of moratorium or not, which is declared under 14, will be a thing which may have to be seen. So with that,
in addition to 14, Abhishek, that falls under section 28(1) also. And I think if that share transfer or sale purchase ultimately results into change in control, or maybe the promoter's equity is being diluted, which is not permissible as per section 28(1), I think that should not be allowed. So
But I would like to add here
some checks and balances.
Ran sir, I would like to add here, this is, if you see the crux of this paper, they are actually more concerned about the minority public shareholder rather than the promoter shareholder or the group promoter shareholder or a large shareholders. So maybe, what I feel is that maybe, we need to re-examine the provisions of law.
These are our initial remarks, not on the discussion paper. These are initial remarks because the discussion emanated from Pavan Vijay's statement. So this is the outcome of that only. Now let's come to the discussion paper.
Yes.
Let me share the discussion paper now. Is it visible to all?
Yes, it's visible.
Okay, yeah. Now the discussion paper, I would like to read the highlighted portion also, only. It says it is essential to recognize the rights and obligations of equity versus debt. I agree. Then it says, as such, equity shareholders acquire the last position in waterfall mechanism. Now here I'm really confused with the language which has been used here. Let's read it carefully. Equity shareholders acquire the last position in waterfall mechanism. Waterfall mechanism is 53. What did they say? In the resolution plan approved by the court for getting any dues or sum at the time of liquidation, as they are owners of the insolvent company. I think some CIRP liquidation has been mixed up by SEBI here in this paragraph. Anjali, do you agree with me?
Agreed, sir. Agreed. I mean, liquidation, insolvency, these points have been mixed up.
Yeah, this I think the person who was prepared may not be very well aware about this process of entire process of CIRP and liquidation. So he has introduced waterfall mechanism in CIRP process, resolution plan. Anyway, then it says, hence equity is also known as risk capital. I understand it's a risk capital. Mr. Pavan also said it's a risk capital. Okay. Now here SEBI has given some figures in the discussion paper. And these figures are actually, they have taken it from April to June newsletter, quarterly newsletter of SEBI, ended on 31st July, released somewhere in the month of September. But now September newsletter is also in the public now. It says 5,636 companies CIRP has commenced since inception as on 31st July 2022. Out of this, 3,637 cases have been closed it means rest 1900 something are pending. And 1703 CIRPs have ended in liquidation, while 517 have resulted in approval of resolution plan. Actually, we should not be discouraged by these figures. These figures are improving day by day. Earlier, the ratio was 1:4, 20% into resolution plan and for 80% into liquidation. Now this ratio is coming down drastically. So 517 plan and 1703 liquidation, no issues. Then it says, from listed company point of view, it says from a listed company's perspective, whether there is a resolution plan approved, there can be broadly two outcomes of such a resolution plan in case of a listed company. What are those two options as per this paper? First option is company remains a listed company post approval of the plan. Company remains a listed company, albeit with significant capital reduction pursuant to resolution plan approved by NCLT. And actually, we have seen even the existing shareholding getting reduced by 99%, 99.5%. Even we have seen those cases also. And later on, SEBI came out with the amendments way back in late 2020 that minimum 5% has to be there if the company wants to remain listed. Minimum 5% public equity holding has to be there. Then second option, they say either the company remains a listed company, or the second option is company gets delisted. How? Either as a part of resolution plan approved by NCLT and the acquirer is saying I don't want listing anymore, or company undergoes liquidation as approved by NCLT. So if there is liquidation, certainly listing cannot remain there. But in case liquidation is not there, resolution plan is there, and the resolution applicant is saying that I don't want any further listing, then it shall be delisted. So these are the two options of delisting. And if it remains listed, certainly listing norms have to be there in the listing provisions have to be there in the resolution plan. Okay. Then it says, coming to the number of listed companies, Mr. Pawan also talked about these numbers. It says that 52 listed companies have been delisted pursuant to approval of the resolution plan, and just only 23 companies continue to remain listed pursuant to the approval of the resolution plan. So 52 cases में तो applicants ने कह दिया we don't want to have continuous listing. Only 23 cases the companies still continue to remain listed. और issues ये सारे हैं 23 companies में. Because where the company has been delisted, small shareholder doesn't have any say at all. But where the company has remained listed and small shareholder is not there, they have raised these issues that हमारी भी कुछ say होनी चाहिए. And it says, discussion paper further says about 70 listed companies are currently undergoing CIRP. Now, if SEBI comes out with these norms, now the future will tell that out of 70 listed companies which are undergoing CIRP, how many will remain listed and how many will remain, or in how many cases the RA will opt for delisting. Only future will tell. Then it says SEBI has received numerous references and grievances in respect of companies that have been delisted. अब उसमें grievance क्यों होना चाहिए? I fail to understand. Where it has been delisted, why the small shareholder should have any grievance?
May I?
Because in this discussion paper also, SEBI has not provided anything for those companies which are going for delisting. Yes, Anjali, please.
Yeah. So when a company goes into delisting, I'll talk about a normal company when it goes into delisting. The procedure is that a fair value is to be determined, which the promoter is required to pay to the public shareholders and acquire a particular percentage of shares, 90% generally, to be so that it is eligible to be delisted. So in a company which goes to delisting pursuant to the resolution plan, in my experience, I have not seen even a single case. I should say, majority of the cases have been with zero liquidation value, wherein the shareholders have really not got anything, as a result of which they are bound to feel that their value, number one, has become zero. Number two, there is nobody to even listen to them, because once the company is a delisted company, it is out of the regime of SEBI. It is out of securities laws regulations, and as such, they cannot even complain to anybody. So that is where these grievances by public shareholders or small shareholders come into place, that once a company is delisted, they are not getting anything out of the entire resolution plan.
It means what you're trying to say, Anjali, if after these new norms are introduced, whenever they are introduced, if a resolution applicant opts for delisting,
Right.
then in that scenario, the SEBI automatic delisting exemptions will not be applicable to him.
Some norms will have to be brought in because
I'll come to that. It's already there
Yeah.
in the discussion paper.
right.
And the fair reading of that clearly says that this delisting exemption shall not be applicable in such a scenario where the RA wants delisting.
Right.
The
And it's somewhere it's even written the value of the business should be given a consideration.
Because I'll come to that, because it says that delisting exemption shall be available only in two cases: wherever the company goes into liquidation, number one, or wherever the RA wants continuous listing, but post offer to the small shareholders, he is not able to garner minimum 5% public shareholding. In that scenario, compulsory this delisting exemption shall be available. Otherwise, delisting exemption shall not be available. And I'm really surprised that this may be a very, very, I shouldn't say the draconian move, but it may be discouraging move for the resolution applicants if they have to follow the delisting regulations and give an open offer to the public. Anyway, we'll come to that when we come to that page. It's there in the meantime. If you want to, it's already there, page number 5 of this discussion paper under point number E, capital E. Okay. Then this paper says that SEBI received numerous references, and what were the references? They have mentioned the references also, that SEBI should intervene in the matter and allot. Just read the language. SEBI should intervene in the matter and allot converted shares of the new entity that comes into being after the debtor company is taken over by the new promoter. How can SEBI allot the shares? How did SEBI accept this proposal even? SEBI cannot allot the shares. SEBI can intervene, I agree, but SEBI cannot allot the shares. And my view is that SEBI per se should not intervene without having any consultation with Ministry of Corporate Affairs or IBPI. I understand SEBI is also an independent regulator, but this particular legislation is under a particular regulator. So if you want to really tweak something within the domain of another regulator, I think both the regulators should sit together and then only some new provisions should come. This is my personal view. Currently, do you agree with me or not on this?
Well, yes, predominantly I do. That SEBI definitely, if we actually go technically by what they have stated, SEBI definitely cannot allot the shares. That I understand. But this is I would rather say it's a more of a phraseology which we are emphasizing on. But the intention of the paper, what I see, if I see the undercurrent of the paper, I see that they want, basically the paper is suggesting that SEBI should somehow supervise, or somehow, you know, they should overhaul, check the entire process of delisting or of allotment of shares to the public shareholders at a fair value. Maybe this is the intention of the paper, which we should suggest, that they don't want interference of SEBI. They just want a regulator to just make sure that the entire process of delisting or of allotting of shares is done in a justifiable and equitable manner, so that all the stakeholders' interest is protected and prevented. That's what my feeling is.
So, Doctor, one of the suggestions which may give is that with respect to listed entities, if SEBI is willing to propose to come out with certain regulations, SEBI and IBPI should sit together.
Right.
Both the regulators should draft these regulations. Okay. The second reference which was received by SEBI is SEBI should decide on giving the right value to the business of the debtor company. Just see that what the stakeholders are writing to SEBI, that SEBI should decide on giving the right value. to the business of the debtor company, and all small stakeholders should get appropriate value of their shareholding since it is only the big players. Now see, this is really which disturbed me. It says since it is only the big players who are now acquiring the shareholding of the struggling debtor company at throwaway prices. On the one hand, IBBI says that not many resolution applicants are there in market. Now, few resolution applicants there who are trying to bail out these ailing companies, and now you're leveling an allegation that it is only the big players who are now acquiring the shareholding of the struggling debtor company at throwaway prices. It means, is it not a question mark on the process which is being followed? Is it not an open system? Whether the Form G or EOI system is not open for all, whether everybody is not having liberty to submit the resolution plan. On what basis can we say that only new players are acquiring the struggling company at throwaway prices? If they are acquiring at throwaway prices, why the COC is approving such resolution plans? I think there's a stricture on the working of the committee of creditors also, on the banks and financial institutions also, that they are not taking a fair call. They are just giving away the company at throwaway prices to the resolution applicants. Okay. And further says, and the retail shareholders get no consideration against their shareholding in the company. That I agree, they are not getting any consideration. So that's so fine. Further, C, a resolution process that leads to override zero value of equity shares in case of companies that undergo delisting pursuant to approval of resolution plan with no prior intimation to the public shareholders to even present their case before the COC is not an acceptable process. This is a suggestion that is received by SEBI. Now, on the basis of these suggestions, what SEBI is proposing now, here are the proposals. Now we need to discuss threadbare all these proposals. A, and I request all my friends, panelists, to please intervene. And if any other participant is also willing to say something, you may raise your hand or you may write in the chat box, and you shall be allowed your speaking rights. So this forum is not confined to the panelists who are visible on the screen, it is open to all.
Sir, in fact, just before we go on the proposal,
yeah,
the issues which have been stated in paragraph 7.
Yeah.
SEBI, for example, they have received numerous references and grievances in respect of companies that have been delisted or the other 3 issues. Now, we may at some point of time discuss that Bhushan Steel matter, because there this issue was raised by the promoters, where under the resolution plans, the total number of around 80 lakhs shares were being considered, and 78 lakh shares were acquired by Tata Steel under the resolution plan. They wrote to the promoters saying that 2 lakh shares we will acquire for ₹2 each. The promoters challenged that before the NCLT. NCLT said nothing wrong in that. The resolution plan is binding on you. The shares have to go for ₹2 from the promoters. They challenged it before the NCLAT, order upheld by NCLAT as well, challenged till Supreme Court. So till Supreme Court, this has been upheld. Now, I don't know whether this issue of taking over the promoter shareholding can even be looked by SEBI now in view of that judgment.
So,
except the public shareholding.
But here, Abhishek, SEBI is not talking about the promoter shareholding.
No, I am saying except the public shareholding.
So, Abhishek,
so that
is
issue,
where...
Yes.
Sorry, please complete. So sorry.
Yes, sir. Yeah, Karan.
Yes. So, Abhishek, that is why there is a suggestion in the paper that the public shareholders, especially the minority public shareholders, should get involved right from the inception in the process. So they should not be given a shock or a surprise when when the plan is approved, and then they have no remedy left, because the law is clear that when the plan is approved, then nothing can be changed or nothing can be overturned. And therefore, this paper predominantly and very extensively suggesting involvement of public shareholder in the process or before the COC, so that they know what is happening and what might end up approved. so that there is no, there is no question of grievance at the later stage. That is what my understanding is.
Then in that scenario, my take is that the IBC should be amended to provide for that there shall be an observer from the small shareholders. There is a representative of the small shareholder as observer in the COC meeting, and notice of the COC meeting should be sent to that observer also. But he should be observer only. Because in case of committee of creditors also the representative is observer only.
Madan sir, I really agree with this, that maybe we can put a suggestion that these small section of shareholders, public shareholder, might have a representative in the capacity of only an observer in the COC, so that they are apprised of the whatever is happening during the process. So yes.
Or if SEBI so it is, SEBI will give a participative right also without having voting share.
But
that
sir,
way-
in case of a listed company, when we are talking about a listed company wherein there are thousands of shareholders, because COC's creditors, number of creditors is comparatively too limited as compared to the number of shareholders which are there in a listed company. To getting on any consensus for such a large number of people may be a difficult task.
And may not be, because in case of real estate also we see there are thousands of home buyers.
Buyers.
And they are being represented through one authorized representative, and there is a system which is prescribed in the law.
Maybe,
The
right.
same system can be here
But
also.
Madan sir, you have raised a very interesting point. Home buyers. Now, are we trying to suggest that the public shareholders are at par with the home buyers, or they are equivalent to home buyers? Because
Not at all.
they are not.
I'm simply on the process of how to appoint an authorized representative, that's all. I'm confined to that only. Because we have to have some sort of mechanism. Otherwise, Anjali is very right. There may be thousands and lakhs of shareholders. So how to appoint an authorized representative of those thousands and lakhs of shareholders and one single representative? Okay. Anjali, you have anything to say on Bhushan?
Bhushan, I will not be able to comment much, sir. No.
You should know.
Yeah.
There is, okay. Coming to this proposal, point number 10 now. The existing public equity shareholders, then they are saying in bracket, non-promoter public shareholders are defined in para B below. Let's go through para B below. Actually, they have thought from many angles, all directly or indirectly connected with the promoters, having any relation and all that have been put in the promoters group. So that's in B. So I'm not going through B only. So they are even the KMPs of the company are also promoters.
I have my own reservations with regard to B, because directors and directors' relatives, all directors are not related to promoters. In a listed company, there are independent directors as well, who are allowed to hold up till 2% of the equity. Then KMPs, they could have been allotted shares under ESOPs. KMPs should also not be a part of the promoter shareholders. They should be identified as public shareholders. Likewise, nominee directors should not be a part of promoters. They are public shareholders. So these three categories should be excluded from this exclusion list.
Okay. Nice suggestion. Dr. साहब ये कल note कर लेना, ये हमारे suggestion में ये जाना चाहिए. I agree with this. I don't know, Karan, you and Abhishek, you.
I completely agree. I also had the same observation when I checked the list, that there are few categories which can completely can be excluded from this exclusion, and they can be categorized as public shareholders. And I completely agree.
Anjali, are you confining to independent directors or all non-executive directors?
Sir, all non-executive directors, because somewhere or the other, NED may be connected to the promoter. But independent directors, that is how the system has been framed, that he is an independent person.
So it is all independent directors.
Yeah.
And all non-executive directors who are not related to the promoters of the company.
We can do that, yes.
And their relatives should be excluded. All KMPs and their relatives should be Mr. S.N. Sharma has raised the hand. He wants to speak. Dr. Sir, will you please allow him? Dr. Jatinder, are you there?
Yeah, doing it, sir. Just Mr. S. and
Mr. Shiv Nandan Sharma.
Mr. Shivnanda. Just trying to get his name.
Regular
Yes.
participant. Hand is
Yeah,
raised.
yeah.
We can see his hand also.
Yes. Right.
He's a regular participant and contributor.
Okay. I'm now not trying. I'm in fact trying to locate his name.
So it's very clear. On my screen, it's clearly visible.
Oh, right. It's there. Okay, got it. Yes. Yeah, enabled.
Yes.
Sir, video is not working. Sorry. Madan sir, one very important matter has happened in Ruchi Soya, where the old shareholders lost heavily and new shareholders have made a lot of money. And in
Sir,
the
this paper is outcome, according to this paper, is outcome of Ruchi Soya only, if you ask me.
yeah. So my request is that kindly study that part while you make your comment with the regulator there, that Ruchi Soya kind of incidences should be avoided and right to recompense somewhere within 3 years, 5 years, right to recompense or a preferential allotment at a preferential pricing for such shareholders, kindly.
No, but that's what this paper is saying, sir, that all the public shareholders should be given an offer to subscribe to the equity at the same price at which the resolution applicant is acquiring the shares. That is what the whole crux of this document.
Yes, and the IPO which came after 1 year, 2 years or so, that there should be a same
That was
footing
the rights
as-
issue. That was the rights issue, sir, not IPO.
Yes. Thank you.
Okay, we can again revisit this at the end of the program. Okay, now the proposal A. The existing public equity shareholders of the corporate debtor shall be provided an opportunity to acquire equity of the fully diluted capital structure of new entity. Now we fail to understand, and then they have written that what is the meaning of the new entity. If you see the very small font size, new entity means the resulting entity pursuant to CIRP. So it's not necessary that in every CIRP process a new resultant entity is there. In majority of the cases, the existing companies are absolutely only the management is getting changed. The entity remains the same. Now, are they trying to confine it to this, whether this proposal with respect to wherever there is new entity and not applicable to the existing entities which will continue? I'm having my own doubts. I think it should be made applicable to all the entities. Whether resulted entity is a new entity or an existing entity is continuing. Anjali, what is your take on this?
Madan
Yes,
sir, if you
yes,
see,
Karanji.
they have a, sorry.
No, please, Karanji, please carry on.
Yes, so Madan sir, if you see that there is a footmark to it.
That's
So-
what I read. I just read
Yeah.
that footmark.
Correct. So there is, again, there's a technical error. So what I see, this paper needs to go through a lot of overhauling, because there are a lot of legal jargons which have been interchangeably used without giving import to the relevance of those terms. So I completely agree. It's not basically a new entity. It's the same entity which has been acquired by the resolution applicant. So there is no point. There is no question of any new entity coming into.
तो सर हमारे suggestions मांग रहे हैं, हमको suggestion देना ही है ना.
बिल्कुल सर, बिल्कुल और बिल्कुल perfect suggestions.
Anjali, your
but I totally agree with Mr. Madan as well as Karan that 99% of the cases, the same entity remains, no new entity comes into picture. Except in 1 or 2 cases, I've observed that there happens a merger as well, wherein any of the entities belonging to the resolution applicant gets merged in the listed entity. Probably they want to cover that scenario here. And maybe 5% equity can also be connected to that scenario wherein a merger is taking place or if a fresh allotment is being made. So 5% equity is to be allotted under those scenarios to the public shareholders as well.
No, but Anjali, the question is whether it's applicable only to those cases or to all the cases or listed companies.
Has to be all cases. Has to be
Yeah,
all
has to
cases.
be all.
Only new entities though will be
Yes,
restricting it too much.
yes.
Yeah.
Yes. Okay, yeah. Then it says the new entity shall endeavor. Now the word is endeavor, though the provision is mandatory. It says new entity shall endeavor to achieve at least 5% public shareholding through such mode of offer made to the non-promoter public shareholders. The offer to acquire share stroke allotment would be made in an equitable manner to such public equity shareholders, and the above mechanism shall be an integral part of the resolution plan submitted by the RA for all listed entities undergoing CIRP. Now, again, I have my own observation on this word endeavor. When the provision is mandatory, it is mandatory. It's you simply say the new entity shall achieve, and the matter ends. Anjali, is it mandatory or not to have 5%?
Sir, it is mandatory. Endeavor, again, you see, maybe in the final paper they'll correct this word, but it is mandatory. When we
फाइनल
go
के
through
लिए
the
जो
entire,
सजेशन दे रहे हैं हम फाइनल के लिए सजेशन दे रहे हैं
हाँ, तो हमें
Final में नहीं
सजेशन
होना
यही देना
चाहिए।
है कि endeavor word should be removed.
हाँ। और इंसिडेंटली उसने गूगल ने भी ना एंडेवर को रेड अंडरलाइन कर दिया ये सामने। Okay. Next proposal. Since subscription from public equity shareholders under such offer to acquire equity of the fully diluted capital structure of new entity will not be in the hand of successful bidder stroke resolution applicant, it may not be possible for the successful bidder or resolution applicant to upfront specify allotting a certain percentage of equity to the public equity shareholders and get the same incorporated as part of the resolution plan. I'm absolutely unable to understand what are they trying to say. I would like to seek the help of my friends in understanding this paragraph. Anjali, I need your inputs also on this because this C actually disturbed me. I couldn't understand this entire C. Pawanji, if you are there, you can give your inputs on this.
See, I think what they are trying to cover is upfront initially itself you cannot mention because after a lot of deliberations only any resolution plan is approved. So it cannot be decided upfront that we'll allot 5% to the public shareholders. So, but resolution plan has to contain the final resolution plan which is approved by the NCLT has to contain those numbers.
Anjali, it has to be there in the resolution plan which is being proposed before the committee of creditors. Unless it is there, because whatever plan is being approved by COC, that plan shall be approved by NCLT.
By the NCLT only, right?
Yeah, so it has to be part of the resolution plan, which is being considered by COC and approved by COC.
Some clarity is needed with regard to this C point, because later in the next paragraph it even says that it will be tech enabled at the exchange level.
Let's read that also. However, to ensure adequate float and liquidity in the new entity post its restructuring through the resolution plan, it may be specified that the entity may be permitted to continue as a listed entity only should be read as if. Only if 5% of the fully diluted capital structure of the new entity is with the public shareholders. the entire process of offering to the existing public shareholders to acquire the shares of the new resultant entity would be tech-enabled at exchanges in a manner to ensure that the speed of the resolution process is not adversely impacted or compromised, and a said offer is executed through exchange mechanism within a short span of time. Now, what I gather from this is that the public shareholders have to acquire minimum 5% shares of the diluted equity of the corporate debtor. Does it mean what will happen to the existing share capital? Is that going to be extinguished?
So, sir, in a normal,
Just because
Sorry.
if it tech-enabled allotment, tech-enabled issue process, it means they have to apply and they will get this share through this process. It means they have to pay money also.
yes,
Is that the intention?
yes, because it is written that on the same terms on which the resolution applicant is getting the allotment, on the same price, equitable, and all those words have been used. So, when they talk about tech enabled, maybe they are looking at something like a rights issue, wherein a 5% equity will be offered to every shareholder as per their entitlement, and then that person has a right to bid for those shares at, say, 2 rupee only, whatever is the price at which the resolution applicant is getting. This is what I infer from this paragraph.
Then my question is, suppose the plan is providing that the public shareholders' equity shall remain in the company, existing equity, though it shall be diluted to some extent, but it will remain there, and post implementation of the plan, whatever is the capital, that will constitute, say, 5% of the diluted equity capital. So in that scenario also, will they have to acquire the shares? If their existing shares remain as it is, though with a bit of reduction.
I think so, because a lot 50%, a lot 5% is the word.
Then there may be a scenario, there is no reason for any allotment. Mr. Ravi Kapoor wants to say something.
Okay, just a second.
Karanji, what's your take on this?
Again, you know what my first, can we allow Ravi ji to speak, because I think I saw him for quite some time, and then I'll give my point of view on this as well. Dr. Saab, could you please?
Yeah, already enabled.
Ravi ji, please, we are waiting for you.
Please unmute yourself.
Yeah, Madhav Saab, if you go to the chart provided at the end of the suggestion, I think the doubts which we are discussing will get clarified. In my understanding is that what you said, if in the plan I am giving you 5% equity, and if I go, then I have to go to the public and offer shares to them to the extent of 25%. And if public doesn't subscribe to that time, I will still continue to be listed because I've already offered 5%. So if you go to the schedule which they provide as an example, I think there will be ample clarity on the discussion point which we are having now.
Okay, then I think we should go through this entire discussion paper first, and then we have a discussion on the issues which are arising out of this. Okay, let's try from that angle also. D. In cases where successful bidder stroke resolution applicant is unable to muster 5% shareholding as per the above process, the company shall go for delisting pursuant to cancellation of the offer made to the existing public equity shareholders, and shall refund the consideration received from the public equity shareholder through the said offer before proceeding further with CIRP. What it means that now the acquirer has come out with a fresh offer, but the shareholder, the public shareholders have not acquired. They have not bid sufficiently to have their share minimum 5% in the post issue or the diluted equity capital. And in that scenario, if the public holding is less than 5%, then the resolution applicant will have to cancel this entire bidding process, refund whatever money received. Suppose 2% ही बिका उसका, refund the entire money received, and then the company shall be delisted. It cannot remain a listed company. This is what the intent is. I think the table will also communicate this thing when we come to the table. Then E says the exemptions, this is what I was discussing. The exemptions granted under SEBI delisting regulations for the purpose of IBC may be reviewed. And exemption from provision of delisting regulation shall be available only in following two cases. What are these two cases? Case number one, where the corporate debtor has to undergo liquidation pursuant to CIRP. No quarrel on this. Second scenario, where the shareholding of public equity shareholders remains less than 5% of the diluted capital structure of the new entity after having exercised the option provided to them to acquire the shares of the new entity up to the minimum public shareholding percentage on the same pricing terms as is applicable to the resolution applicant. Now, suppose post this offer to the public shareholders, if the minimum public shareholding is less than 5%, then the company shall be delisted and the exemption from delisting regulation shall be available. This is what this discussion paper is saying, that exemption from delisting regulations is applicable only in two cases. Case number one, liquidation, and case number two, where the MPS of 5% is not achieved and the company shall be delisting without following the delisting regulations. Anjali, is it okay? It's fine?
This is fine, sir.
Okay.
Yeah.
Anybody else? Anybody wants to have?
Because the company, the RA tried to offer the shares to the public, they have not taken up the shares. So the exemptions as available under the delisting regulations should be available to such a company.
So it means no further extension for having this 5% MPS shall be provided.
Right.
Anjali ma'am, I have a observation. I can understand point one is completely taken. For example, if the resolution application is not approved and the company goes into liquidation, fair enough. The question of delisting doesn't arise because the company is going into liquidation. And therefore, the delisting exemptions doesn't need to be applied, or the question of exemption also doesn't arise at all.
Right.
In point number two, where the intended delisted company is not able to meet the threshold of 5% minimum of percentage of public shareholding.
Right.
Why should they be exempted from the delisting regulations? And on what ground? What is the basis and rationale? Because you have more experience. I want to understand from a legal point of view, what is the objective of exempting such companies which are failing to meet the threshold of having exemptions available to them? What is the benefit of such a thing? Because end of the day, then they are getting delisted and they're becoming a delisted company, and then they should ideally they should go through all the regulations, delisting regulations which are required to be complied with.
See, what I understand from this is that in a resolution plan, generally the new promoters or resolution applicant is getting the shares at actually a very, very nominal price as compared to the face value or the running market price pre-resolution plan. And if say presuming 10 rupees the face value, running market price was 100 rupees. Resolution applicant is getting his shares at 2 rupees. If the public is not willing to take those 5% shares even at 2 rupees, that means the public is understanding that the fair value of that scrip is not even 2 rupees. So in a delisting process, if they expect that they should be paid back on the basis of the fair value of the company, on one hand, you are not even willing to take up the shares at 2 rupees, and on the other hand, you are wanting the money at the running market price or at whatever price. So probably that is the reason why they've been allowed these exemptions. So the people have virtually written off the company, and they're not even wanting to take that 5% at that nominal cost.
Well noted.
What they're trying to say that RA is having intention to offer 5% to the public. But public is not willing to subscribe up to 5% even. So in that scenario, the company will have to be automatically delisted, and the delisting regulations shall not be applicable. There shall not be any offer with respect to delisting. Now here a connected question, Anjali.
Yes,
Now
sir.
onwards, after these regulations become, after discussion paper, SEBI comes out with the regulations, can there be a resolution plan in case of a listed company which simply says that we want delisting?
Yes, yes.
But in that case, delisting regulations shall be applicable.
I think that would need some clarity.
No, but here what they are
Yeah,
proposing.
I mean, yeah, they have mentioned very clearly if they're not able to get the 5%, then only it can be delisted, and those exemptions will be available to it. Clarity would be needed. I think PhD can put it as a suggestion or a question.
Now, what I understand is that if the resolution applicant decides from the word go that they don't want to offer 5% and their intention is to get delisted, then in that case, the whole process of failing to reach threshold doesn't arise, and therefore the delisting exemptions will not be applicable. But in case the resolution application runs this exercise of offering public shareholding of 5% minimum, and there they failed not because of themselves, but because of the reasons attributed to other factors, then they are giving an exemption because they actually tried and attempted, it failed. Simple. So I see a somehow logic where the intention of the resolution applicant is reflecting, and therefore they're giving a little bit of relaxation as far as formalities and regulations are concerned.
But Karan, having said that, if any resolution applicant has to go through the entire process of delisting and has to pay to the public shareholders the fair value of the scrip, none of the resolution applicants, the numbers which Madan sir was saying in the beginning that this ratio has really improved, I have my own doubts that in times to come, this ratio will improve if
Exactly,
everybody is asked to follow the delisting regulations.
That's what my point is.
Yeah.
So are we suggesting as a group together, and especially PhD CCI, that no matter what, the delisting regulation should be exempted if the company is going through a CIRP process?
Yes. Yes.
So, okay, fair enough. And it's a good suggestion.
Yeah, open offer should not, there shouldn't be any open offer.
There should not be any condition for delisting exemptions.
Yes.
Delisting exemption should be applicable to all the CRP companies.
So if he wants delisting, it should be allowed. If he doesn't want delisting, if he wants a continuous listing, then certainly minimum 5% minimum public shareholding norms will be applicable.
Agreed.
Agreed.
That should be our proposal.
A good suggestion.
Yes. Now, whatever we have just read and tried to understand, now they have tried to summarize that in the form of a table. They are given an example. There is a company A, and this is the existing equity structure of company A. Promoters are holding 60% and public's shareholding is 40%. Right. Now they say the COC, this company goes into CIRP now. The COC, after following due process laid down in IBC under regulations framework of IBBI, chooses a resolution plan submitted by a group or entity XYZ. Now, as a part of the plan, this resolution applicant XYZ promises to gain control of the company. Now, I don't know where from this language is coming. As part of the plan, XYZ promises to gain control of the company. Why should we write? But we are in the whole discussion paper, we are doubting the intention of the resolution applicant. They are saying XYZ promises to gain control of the company by clearing certain percentage of the dues of the lenders. The following table demonstrates the minimum offer required to be made to the shareholders at serial number 2 above, in order for A to remain listed for various scenarios. And these are the scenarios. Now they are saying post approval of the plan, shareholding of XYZ in A as a result of resolution plan, suppose it is 75%. As per the plan, they are saying that RA's equity shall be 75% and all the equity shall be reduced to 25%. Now, what is next? Post reduction of the shareholding of existing shareholders, shareholders of serial number 1, that's the promoters, shall be reclassified as non-promoters and they shall be holding for 15% and public shall be holding 10%. अब ये मुझे, I'm not able to understand this. You are here, you are off, if you are reducing the existing share capital, say up to 25%, now this 25% shall be divided in two parts, 15 to promoters and 10 to public. I mean, in the same ratio, the ratio which they were enjoying earlier. So it is either going to benefit public as the promoters. Anjali, I'll seek your indulgence on this. If not today, maybe by tomorrow in
Sir,
writing.
I think we'll have to really understand this table.
Yeah, because tomorrow is the last date of giving us solutions, and we must be clear before we put something in writing.
The minimum offer shall be made to the public.
Well, what my take is that if they actually accept our proposal and suggestions with respect to the main proposals and the agenda of the subject paper, then this analysis and this is demonstration. So this demonstration would automatically change and they'll have a revised table whatsoever completely. Right now, this table is supporting the suggestions and the proposals which they have made above. So if there are any alterations or altercations, and if there is any acceptance of a suggestion, then this table would have no meaning whatsoever. And actually, you are right. Even I could not get a head or tail of this table, how to have any discussion whatsoever basically. But Raviji has mentioned this. Raviji, would you like to throw some light? Because you mentioned this table when we were talking about point C, and you wanted us to refer to it. So Raviji, if you could throw some light on it, and maybe we can have a better suggestions.
Yeah, so thank you. Actually, here in the first part, what they are doing is they are not considering promoters' equity to be written off totally. So they are proportionally allotting to everybody irrespective of their category. So normally, Madan sir would agree, and most of the result plan, what they do is they don't give any equity or repayment of unsecured loans to the promoters. So if the SEBI is looking at the small shareholders, I think in this clause also they should say that if the RA wants to keep 25%, they should give 25% to those 40% shareholders and not to the promoters. That would be the suggestion. I mean.
Yeah, exactly. I'm absolutely. You just hit the bullet in the right time. That's what I'm trying to say. Why promoter should be given something?
Exactly.
That also in the same ratio which they were enjoying earlier. So let's leave the table then, and we give one single suggestion.
Sir, tell me one thing. Even Mr. Kapoor can answer this question. If I look at the last row of this table, for rest of the above rows, 75%, 85%, 90, 95, 97, wherein in the last column it has been up till 0%, 0, 0, 0, and 2%. I agree that the company will not be remaining listed entity. But if I look at the last row, wherein the shareholding 100%, old capital has been reduced to 0%. Then the old promoters have been reduced to 0%. Old public has also been reduced to 0%.
Right.
The public shareholders, old public shareholders were offered equity up till 25% pursuant to the resolution plan, and they have accepted up till 5%. So if I look at this last scenario, I think I'm entitled to remain a listed entity.
Right. Sorry, I just lost in between. They are accepted to 5%, then company will continue to be listed.
Company is entitled to remain a listed company.
Yes, they are entitled to.
They are entitled. So meaning thereby, when till the time you are not getting this, you offer 25%.
Yeah.
And the public accepted 5%, 5 or anything more than 5. Right. You will remain a listed entity.
That's true.
Yeah. So, Madan sir, I think what I was saying that maybe it will be through a process of rights issue or something like rights issue only, wherein the company will offer 25% of the equity to the shareholders, existing shareholders. Our entitlement ratio will be determined on the basis of their existing shareholding in the company.
Right.
And then they have a right to accept or not to accept that entitlement.
That's true.
Then only that 5% can be reached at.
अब मैं इसे summarize करता हूँ अपनी तरफ से. I'm on this 100% line only.
आपकी summarization तो जरूरी है सर.
That what does it mean according to me? That the existing shareholding of the promoters and the public can be reduced to 0.
Yes, it can be.
That's permissible. Number
Right.
one. Number two. Now the resolution applicant has to make an offer to the public shareholders at the
Right.
same price at which the resolution applicant has acquired the shares.
True.
This offer has to be for minimum 25% of the diluted equity share capital.
That's true.
No, but
Just
from
a minute.
nowhere.
Yeah. That's true. Madan sahab, you're on the right track. Yeah, you're on the right track.
But from
just a
nowhere
minute.
in the discussion paper, it is coming out that it has
Yeah.
to be at least to the tune of
You
25%.
read the second last column. It says
Yeah.
minimum offer.
I'm not, except for this table, from nowhere else it is coming out that offer has to be for at least 25% to the public shareholders.
This is what they are saying.
Mm.
This is what the table is
This
saying.
table is saying that, I agree.
So I think the moment you put this 25%, na सारे resolution applicant भाग जाएंगे. Okay, anyway, let not come to the conclusion. Now, what is trying to say? Minimum 25% offer to the public shareholders, and then public shareholders have to subscribe to minimum 5% of their diluted capital.
Right.
In order to ascertain that the company remains a listed company. But if the public shareholder do not subscribe to 5% or minimum 5%, then the company shall be delisted and the company delisting regulations compliances shall not be applicable. This company shall be exempted from those regulations. Is it the crux of the entire proposal?
That's true, Pradhan sahab. That's what it is.
Now a counter situation to this, wherein I do not reduce the public share, I reduce the existing promoters holding to 0, acceptable, okay. I reduce the public shareholding, existing public holding to say 2%. So
Right.
post expanded capital of 2% will be retained by out of my existing capital.
Right.
Right.
And when I offer this 25% to the public shareholders, they
Right.
accept only up till 3%,
Right.
3.5% say. So will my existing 2% plus 3.5% will be added to make it 5% of the public
Yes.
holding in the company?
Yes, that's
To
true.
my understanding,
Absolutely.
yes.
Yes, it is. Yes. So if you look at
This
one,
can also come with a more clarity in the regulations.
And one
In
more
my
thing
view,
is there. One more thing is there. Suppose I am holding 100 shares and I am offered 50 shares.
Right.
Let's not go to the calculation. Am I entitled to apply for 50 shares only? Or as in the case of rights issue, I can apply for more also.
no clarity on that, Madan sir, for sure.
Actually,
But
that one
Sir,
should-
then in that scenario, there can be people who will be willing to take up much more than their entitlement.
let them.
अब ₹2 का शेयर अगर मुझे मिल रहा है,
The promoter, the resolution applicant can say, I'll accept up to 25% only.
that is okay. He'll accept only up to 25%. But there may be people who will be more than interested in taking up the share and then creating nuisance value.
But you see, if you don't give this option to them, and the total bids which have come to the company are less than 5%,
it has its own. Yes. Definitely there are.
and the company will be delisted. So
Definitely.
at least to save the company from delisting, that
Right.
option is given.
Yes.
That we can apply for more.
In any case, acceptance will be on proportionate basis only, pro rata basis only.
Nandan ji kuch कहना चाह रहे हैं?
Madan sahab, you are absolutely right, because everybody may not subscribe or may not be able to subscribe. So people should be allowed to subscribe higher amount and allocation can be done up to 5%. I want to only say one thing. You have taken one decision that the RA can decide to delist the company. So now whatever suggestions are going on, so if the RA is wanting to delist the company, in that situation, what will happen?
In that scenario, as far as the existing discussion paper is concerned, the RA will have to make an offer for delisting. As per delisting regulation, that exemption shall not be applicable. And what we are proposing through the chamber, that in such a scenario also, the exemption of delisting regulation should be provided to RA.
My view here would be that a lot of people are ready to subscribe to unlisted shares. So in such situation, the existing shareholders should be allowed to pitch in their money to the extent of 5% minimum. Because later on, after 1 year, 2 years, if he wants to relist, then what will happen? He will actually come up with a offering of either promoter shareholding, book building, or some other route. So here, in case is delisting, which is your suggestion and which has been unanimously resolved by the people here at the bench and so in that case, the public should be allowed, the existing shareholder should be allowed an option to subscribe to an unlisted share.
सर आप ये थोड़ा लिख के भेज देंगे कल सुबह तक.
नहीं, मैं ये आपको WhatsApp या मेल कर दूंगा, but what I'm saying is that you see, we were initial supporters of Paytm, and in Paytm the unlisted share was being traded. Today, Bira, the beer share is being traded in anticipation that it will be listed in future, and the shares are priced 1,000 rupees plus the 10 rupee share. So I can write that in case he is wanting to delist the company, then the existing shareholders should be allowed to pitch in money in the unlisted future company. Is it right? Do you agree? First, if you agree, I will write.
Please, I agree. आप लिख के भेजिए जरा.
Right, sir.
एक और observation, Anjali, that is as per MPS norms, the 5% has to be there at the time of resumption of trading. Companies under CIRP.
Okay.
Now this 5% to be raised to 10% within 1 year.
Right.
And to be raised to 25% within 3 years.
Right.
So these time windows have been provided.
Right.
But as far as here this discussion paper is concerned, there is no timelines. Immediately.
So that is already there. So that is why it is.
Just a minute. Here in this case, this 25% of a minimum 25% offer has to be there in the first stroke itself.
So that is what I'm saying. It's not the 25%, although they have given in the example, but it's not coming anywhere from the discussion paper, from this discussion paper, that the offer to the public has to be of minimum 25%.
The discussion paper should provide some clarity rather than creating confusions. Okay, because according to the doctor, ये भी लिखना timelines have to be provided in the very first stroke. It cannot be 25% offer to the public shareholders. Now they have written some merits, and I agree with these merits. Company will be able to retain its status as listed company with minimum public floats post restructuring. Fine. Burden of successful bidder will be lesser as capital for part equity in the new entity can be met through offer to non-promoter public shareholders. And the resolution applicant shall have this additional source of raising money and at the same time shall also comply with MPS. Here I don't agree. Resolution applicant may not agree that I want your shareholding. I will subscribe to the entire shareholding. I don't want your money at all. क्योंकि आपको same price पे देनी है मुझे जिस price पे मैं ले रहा हूँ. Why should we have the same partners from outside from the public at the same price at which the resolution applicant is subscribing to the shares? Existing public shareholders of the company under CIRP become shareholders of the company post restructuring. Agreed. Existing public shareholders will have a right to participate in proportion of their shareholding. Now here my question is coming. In red, I have written actually here. Can they apply for more? Because they are writing that in the same proportion. It means additional shares are not permissible. Application for additional shares is not permissible. I think it should be permissible.
Madan sir, just one point on your same price. I think SEBI forget the fact that other than putting in equity, the RA is also paying to the secured creditors, operational creditors, PF, etc., etc. So what would be that quantum or value which SEBI is, I think, is not considering to take into consideration while determining the value of the equity you are taking that.
और एक चीज और है ना रवि जी, आज
हाँ
की
जी।
डेट में आरए अपना प्लान दे रहा है, वो कह रहा है 10 करोड़ की कैपिटल डालूंगा, 90 करोड़ के मैं डेट्स डालूंगा इसमें।
Exactly.
अब 10 करोड़ की कैपिटल के हिसाब से उसे बाकी ऑफर करना पड़ेगा।
तो इफेक्टली क्या होगा मदन साहब, मैं 100 करोड़ की इक्विटी डालूंगा 10 + 90 के प्रीमियम पे, और अब आ जाओ, आप 90 पे प्रीमियम पे लेना है तो अब आ जाओ।
I think this is actually discouraging the
Exactly. Absolutely right. Absolutely right.
And that's why I'm saying that on the one hand, our regulator is saying, IBPI is saying that RAs are not there. And here SEBI is saying, coming out with this paper, both the regulator must sit together before they can finalize this document.
Absolutely right. So that's one thing, they are not considering the other contribution being made by RA. That's the key of any resolution plan.
Okay, this is all about this discussion paper.
Sir, I have another observation, and it is a suggestion as well to SEBI. I have seen in many of the cases that once they are out of the resolution, out of the CIRP process, then it's very difficult for them to appoint independent directors or to initiate for the new person who has come into a listed regime for the first time. It is very difficult for him to understand the entire compliance process. And the day you are out of the CIRP, the meter with regard to compliances start ticking, and they are imposed penalties on per day basis. It is virtually like a patient coming out of coma and he's being asked to run a marathon. So, accordingly, penalties should not be imposed on such company for a period of at least 1 year. There should be a moratorium period available to a company which has come out of CIRP and has been taken over by a new promoter. Maybe we can add this as well as a suggestion.
So currently, Anjali has given a food for thought that we should have a one program specifically for listed companies, that there should the certain exemption from LODR should be given to these listed companies at least for a particular time period.
6 months, 1 year, whatever.
Yeah,
whatever the regulator
on
deems
that, and
fit.
we should give a discussion on that, give our suggestions to SEBI.
Yeah.
Yes, sir.
So Madanji, just to add up what Anjali ma'am is saying is that if you go practically, the process of getting, even after the approval plan, process of getting listed itself gets extended to 6 to 9 months because of their committees taking into consideration old lapses, waiving of those penalties, etc., for the plan, and then going for listing. So when you're making a suggestion, you can also say that that the other compliances or the earlier should be condoned immediately, and company should be put on the for trading platform as early as possible. Effective.
Good. But no, we will not. We'll have a separate event on that along with this.
Just to continue with what Anjali ma'am said, that's what I pointed out this way. Otherwise, not on this circular of this.
Not on this circular, yeah.
So this is all from my side. Now over to my dear friends Karan and Abhishek and
Madan
Anjali.
sir, I represent few private equities in the country, including IFC Washington and others.
Sharma ji,
At times people are taking their support.
Participants will start exiting. Already 40 से 28 रह गए हैं.
मेरे को 2 मिनट देने चाहिए कि अगर कोई convertible debentures से scheme लाता है, and where he says that if future performance happens, because most of our PE says that I'll convert at a future performance at a multiple of PE, any resolution applicant wants to bring in such investment by saying that, look, you also invest, I also invest, and let the premium be decided on my performance after 2 years, 3 years, 4 years. Shall that provision be left here or no?
Sir, I'll have a separate chat with you, definitely. Post the event, I'll have a separate chat with you.
So we can have final remarks from Mr. Karan Mehra, the concluding remarks.
So first of all, I would like to thank Anjali ma'am and Pavan sir for giving so much time to us and giving so much of input. So what I heard and what my conclusion is, first of all, this paper is, it has to be a balancing act between the interest of the shareholders and the interest of the resolution applicant. Right now, what my understanding is and what my thoughts are that this paper is more heavy towards public shareholders and not the resolution applicant, and which is actually defeating the purpose for which the IBC code has come into the enforcement. We have to take care of resolution applicant as well. And this paper at the present stage or state does not reflect such a situation. I also feel that SEBI and IBBI together should rework on this paper, and this paper needs a complete overhauling on various aspects. I also feel that the first suggestion which came from Pavanji, that there should be a transparency and the information should be on a public domain regarding the initiation of the corporate insolvency resolution process should reach out to shareholders through stock exchange, and the orders passed, effective orders, all the orders which are getting passed on a regular basis should be in the public domain for the shareholders to take this action. Then I also feel that the grouping of category A shareholders, especially what Anjali ma'am said, that few of the categories should be removed from the exclusion. For example, KMPs, nominee directors, all non-executive directors not related to the promoter groups, and independent directors. They should be looked after carefully and separately. And I also feel, and I agree with Anjali ma'am, that there is nowhere in the paper which suggests that we have to allot 25%. All they are suggesting is that if you want to remain listed, you have to meet the minimum threshold of 5%. And if you fail to, then you get dislisted. And my last suggestion is that PSG should insist that all the companies which are under CIRP, whether they are listed or they get delisted, they should be exempted from the delisting regulations. And that's my conclusion. And I hope I cover most of the point.
Thank you. Yes, Abhishek ji, your take.
Sir, my take is actually twofold. One being that, as you rightly pointed out in the beginning, that the entire issue of section 28(1) during the CIRP process, whether that structure can be changed or not, that in fact SEBI will have to look. And although this discussion paper only raises the issue which concerns only the public shareholders and the resolution applicant when the resolution plan is being proposed. But I would say that SEBI will also have to look into the aspects of overriding effect among the SEBI Act and the IBC, for which various, in fact, matters are tagged and pending before the Honorable Supreme Court, where the issue of whether SEBI Act will have an overriding effect or not. In fact, if we look at these suggestions which are being made by SEBI, will be tested again, because if you say that 5% will have to be, a company will be delisted if you do not meet the criteria of 5% public shareholding. Assuming a plan is approved and the RA wants the company to be continue to be a listed company, but you are then making the requirement of 5% to be a mandatory one, whereas section 31 says the plan as approved will be binding on all, including SEBI. So these issues, I think, at some point of time will have to be looked into.
The Abhishek, 5% already ho chuka hai. That's
Look,
already.
that is as per the regulation. Now I am saying that if tomorrow this Honorable Supreme Court says IBC will override, then whether that regulation,
then somebody has to challenge that 2020 amendment of SEBI. But now one question of my mind mein aa raha. Suppose promoter, this resolution applicant is saying that post resolution plan approval, the public shareholders' equity in the company shall be 5%. So in that scenario, will there be any open offer?
Madan sir, if you go to the chart, yes, you'll have to make open offer of 20%.
No, but
No, but the example which I gave, wherein 2% is retained of the old capital and only 3% is accepted by the public.
there,
So
there
then
it's
also
okay.
we came to a
There it's
conclusion.
okay. There
But
it's
sir,
okay.
no, the idea is public holding to be 5% of the post resolution capital.
Right.
So
But if the
agar
RA is saying, as per the existing capital shall be reduced to that extent that it remains at minimum 5%.
Right.
So in
Madan
that
sir, we'll have to
scenario, will there be any open offer?
Yeah, Madan sir, we have to go back to the chart again, where you say 95%, 20% की open offer करनी पड़ेगी.
Chart
20% की offer करनी पड़ेगी, sir. 20% की offer करनी पड़ेगी.
I think, Doctor, we need to seek clarity on this also. That's confusing.
Sir, 25% तो करनी ही पड़ेगी over a period of 3 years and 5
Sir,
to
over a
25.
period is fine. I agree. Over a period is fine, but here they are not providing the period. That's not my question.
In fact, there is one issue which comes up that if there are 5 RAs, the RA which offers the best to public, though I think the IBBI is soon likely to get away with evaluation metrics. So I should be allowed, if I am the RA who says I will offer to the public at par and I will pay to 5 rupees premium, then the plan which is better for public should get more value on the evaluation, because the RAs should be favoring the public. I'll give at par and I will subscribe at premium as RA. So,
Sarmaji, we are forgetting it's a creditors legislation. You can't give this evaluation metrics right to somebody else.
no, I'm just saying, sir, the RA which offers better to public, why there should be a restriction that public must subscribe at my price? I'm ready to offer discount to that public.
So, but no, what I think then, okay, another question.
The SEBI norm says it should be minimum at par,
object of
because the valuation of the share is 0 and it should be minimum at par. It cannot be issued at discount, but I am ready to take at premium at as RA. So I should be getting a better position. Why public must subscribe at my price?
Sir, if you are taking the share at 100 rupees, you will have to give offer at 100 rupees. You cannot have more than 100 rupees from the public shareholders.
No, I want to give them at 90.
Yes, that should be allowed.
So this should be our suggestion, that
Yes.
it should not be at same price. I can offer a discount, but not less than par.
Yeah, so it cannot be. He has to offer the shares at a price which is not more than the price at which the RA is acquiring the shares.
Perfect statement.
Good. Nice suggestion. Thank you. So, Dr. Sir?
Yeah, thank you very much indeed. It was a very, very, I can say, very productive, conversation.
I didn't expect that we have 1.5 घंटा कैसे निकालेंगे, मुझे लग नहीं रहा था 1.5 घंटा तो बहुत ज्यादा इसके लिए.
इस पर 1 घंटा और भी discussion हो सकता था.
Right.
So anyhow, in fact, I thank you very much to Madan Saab, Mr. Karan Mehra, Abhishek Anandji, and all our distinguished panelists who have shared their very, very important and productive views. We'll be, in fact, we have jotted down most of the points, and by tomorrow we expect that if any of you wants to share any important points, please do mail us, send us the mail, maybe before 12 noon. So you'll be, in fact, consolidating all the points in the second half, and finally in the evening by 4 p.m. we'll be sending our recommendations to SEBI. So I request you to kindly share your points.
Madan, he will forward it to you. Madan Saab will be.
I'll do that.
I'll just put our mail ID here in the chat box. If anybody else wants to send us directly to us, you are most welcome to send us on this email ID.
And Doctor, I'll give you the contact details of Anjali also. If
Yeah,
you don't
please.
get any response from her, you can have it.
100% sure, sir. Sure. So,
Right.
So looking forward to your participation in our future endeavors also. Although we have many of the participants who have been there with us in lot of our past sessions also. So with same momentum and intensity and energy, I request you to please participate with us in our future programs also. So thank you very much, and indeed we look for your continuous support, and also look for some good recommendations that already we have been discussed today. They see light of the day when SEBI is actually finalizing this paper. And one of the important aspects has been told that SEBI and IBBI should in fact sit together and finalize this paper. I think that's the most important point that has come out. so that everybody is on the same page and same wavelength. Thank you very much. Thank you indeed. And
Thank you. Thank
Thank
you.
you. Thank you, everyone.
Thank you,
Have a
everyone.